up here to introduce our last speaker. You have seen him already today introducing other speakers. His name is Alan Mendenhall. He's the Associate Dean at Faulkner University here, the Thomas Good Jones School of Law, and Executive Director of the Blackstone and Burke Center for Law and Liberty. He earned his BA in English from Furman University, his MA in English from West Virginia University, his JD from West Virginia University College of Law, his LLM in Transnational Law from Temple University, Beasley School of Law, and PhD in English from Auburn University. That is a lot of degrees. He is the author of hundreds of publications and has worked in a variety of positions in private practice, government, and academia. His books include Literature and Liberty, Oliver Wendell Holmes Jr., Pragmatism, and the Jurisprudence of
Agon.
Of These and Boys, Lines from a Southern Lawyer, The Southern Philosopher, Collected Essays of John William Corrington. I want you to bring up Alan Mendenhall. Thank you so much.
Thank you, Anna Jane. The title of my talk is Why Do Lawyers Cost So Much? And when you are a lawyer, you get kind of nervous about a talk like this. Like you might leave the building and there's an SUV with black tinted windows following you or something like that. So I'm here today to be something of a traitor to my class, a traitor to my guild, as you'll come to see. And since I'm already acting in that capacity, I may as well tell a few lawyer jokes to start us off at our own expense. So what's the difference between a catfish and a lawyer? Does anyone know? One's a scum-sucking bottom feeder and the other one's a fish. What about the difference between a jellyfish and a lawyer? Does anyone know that? One's a spineless, poisonous blob and the other one's a form of sea life. What's the difference between a lawyer and a leech? A leech stops sucking your blood after you die. Okay, that's enough of that. But if you do see like a red laser pointer on my forehead or something, let me know, because sometimes lawyers can be touchy about these things. So why do lawyers cost so much? When we talk about cost, we always go back to supply and demand, right? And if you look in a textbook, you might see a definition for supply and demand that says something like the quantity of a good rises as the market price rises and falls as the price falls, or something that indicates that when supply goes up, price generally goes down, or when supply goes down, demand can rise, so price will probably rise too, something like that. But I tend to think of this concept in terms of scarcity. I think that's a helpful way of looking at it. You know, diamonds are scarce commodities, right? And so they are generally costly things. And part of that's in light of their properties too. They've got certain properties like hardness that other things don't have. But scarcity is an element of their cost. If you think about air, I mean, there is a superabundance of air. We don't pay for air. We're all breathing right now for free. It doesn't cost us anything. Now, if we were 20,000 leagues under the sea, I don't know if you ever read that book when you were a kid, but it's a good book. But if you're under the ocean, you know, air would be worth something. You know, you would want oxygen. Same thing if you were like hiking the Himalayas or something. Then you would want air. Then air would cost something. Well, everybody complains that we have too many lawyers. If you go online and just do a Google search like, are there too many lawyers or something like that, you'll see all kinds of rants on the blogosphere about how we just have too many lawyers and we need to get rid of some lawyers, all that kind of stuff. I'm not going to argue against that today. I tend to believe that that's not necessarily the case, and even if it were, I don't think that too many lawyers is necessarily a bad thing. But I'll just presuppose that that's true. So let's just say there are too many lawyers. Then how could the price of legal services be so high? Why does it cost so much to hire a lawyer? Does anybody know what my answer is going to be? Can anybody guess? By the way, what are you going to say? Yeah. Because the money costs to go to law school? Okay, that's going to be part of it. Yeah, so that's good. Do you want to come up and give the rest of the lecture? Or, actually, a Rasmussen poll recently this year said that that 54% of Americans believe there are too many lawyers, so just a little over half. But the answer that I'm going to give involves guilds. Can anybody explain what a guild is? Does anyone know what a guild is? I can't quite hear, but yeah, it's like a group. So a group of people of an occupation, like artisans or merchants, and they band together and they form an association. And what does this association do? Yeah, keep prices high, basically. Yeah, that's what they do. They try to protect their industry. They try to protect their own profession by implementing anti-competitive practices. And these could be anything from trade regulations to occupational licensure to other forms of barriers to entry. And that's how they make sure that they maintain prices high. So guilds sort of reached their zenith as an economic model during the medieval period. I mean, there were antecedents in ancient Rome. There were guilds called collegia, and they involved sort of university-style guilds. But that's not quite what we're talking about when we talk about what's going on in the medieval period, when we're dealing with masons and knife makers and locksmiths and harness makers, artisans, chain forgers, carvers, glass workers, metal workers, each with their own guild. Guilds were unknown to England prior to the Norman invasion. So prior to William the Conqueror and the Battle of Hastings in 1066, England didn't really have these types of guilds. It also didn't have the same sort of centralized governing authority that materialized after the reign of William the Conqueror. Interestingly enough, at a certain period, early in the medieval period, there were some guilds that were still under pagan influence. And the Catholic Church tried to crack down on them and Christianize them because they would have these banquets and they would hold them on pagan holidays, and they would be just, big sort of drunken parties at which everybody was required to pledge loyalty to the guild. And they had like secret society type initiation rituals and all these kinds of things. So the Catholic Church, the only church at the time, was uncomfortable with this and sought to really Christianize guilds, and that happened gradually throughout the 14th century and 15th century. Now we still have guilds with us today in residual form. I'm about to talk about one, which is the legal profession, but in its early manifestation, guilds were somewhat different. So what you would have is you would have apprenticeships. You've heard people talk about apprenticeship models. And apprentices were basically day laborers. They were paid an hourly wage or a day's wage for their work, and it wasn't a lot. So if you came from a poor community or a poor family, you really couldn't afford to go in and be an apprentice for however many years it took in order to actually earn real money, because you were just giving up too many years of your life for too little economic benefit. After you were an apprentice, you could reach a stage that was called a craftsman. So you would become a craftsman. That was like you graduated from apprentice to craftsman. Now we know that there are companies called like master craftsmen, and we've heard of master in the term of say like Sensei and Splinter from Ninja Turtles and that sort of stuff. And what you would do after you were a craftsman, if you became a master craftsman, that was sort of like the next step. But before you could do that, you had to become a journeyman. And what a journeyman did was, a journeyman was sent off for about 3 years to go throughout Europe and to explore different countries and how they did stuff. So let's say you were an iron worker or something. So you would go off to France or some other area of Europe, and you would learn the trade secrets of other members of that guild from other areas. And then you would come back, and that knowledge would be part of your training. That 3-year knowledge would be part of your training. Now, we've heard of the term masterpiece, right? And we think, Michelangelo and things like that, and Donatello, and I don't know why I'm going with the Ninja Turtle themes today, but we think about artwork. But masterpiece was also what was required. It was a prerequisite to becoming a master, to becoming somebody that was at the top of your guild, the height of your guild. So you had to come up with a project, and that was your masterpiece. Now, guilds were authorized by monarchs. Now, why would a monarch authorize a guild? If you were a monarch, why would you allow a small group of people to have a monopoly on this professional service and to regulate trade and all that kind of stuff to their own benefit? Why would you allow that to happen? Does anybody know? Imagine we don't have iPhones and all that kind of stuff, but imagine you're trying to tax people and you're trying to tax industry. Isn't that a lot easier? And when you've got these consolidated guilds, and so you can kind of number people, you know who's a member of the guild, you've got tallies on everybody, you got a head count, you got all that stuff. So the formation of guilds made it a lot easier for monarchs to tax. And not only that, but if you're the monarch, now you have something with which to exchange favors, because you know that the people that are rising to the heads of the guilds are the most powerful people in their community. And monarchs are always paranoid about consolidating and keeping their power, right? They have to keep these barons happy and these nobles happy and these rich people happy. Well, what better way to do that than to bestow grants and privileges upon leaders of the guild? So now you have that. Not only can you tax them more easily, but you also have access to the people who are in the most control of the masses within their little town. So that's the other thing about guilds, is they were also associated with the town. So municipalities to this day are corporations. I mean, you incorporate as a municipality. They're quasi-state, quasi-private entities. Well, towns in the medieval period were associated with particular trades. So you might have a town that was associated with, I don't know, some kind of metalworking or wool or silk or whatever it was. Or you could have a town like Bordeaux or Champagne that were known for what? Wine and stuff like that. So the entire identity of a town is bound up with whatever the identity of the guild is, whatever good and service that guild is producing and trading and controlling. Now, what would the guild do to control its power? What are forms of barrier to entry? So I've talked about the apprenticeship model and how that worked, but there would also be other restrictions like unauthorized practice. All the lawyers in this room already know what we're talking about when you hear that phrase, but if you were somebody that tried to come in and practice a profession over which the guild had control, well, the guild would either fine you, it had the power to put you in jail, it basically had the power, under the authority of the crown, to prohibit you from practicing that profession. Now, the guild system began to die out in the late medieval period, in part for a number of reasons. One is that there were class conflicts that developed within guilds. So you had judges and notaries and doctors and druggists, or what we would call pharmacists today. And those are the people that are sort of like at the top of the class structure of the guilds. And then some of the people that are doing raw materials and weaving baskets and making saddles and baking things, and they're sort of on the lower rung of the class structure. And there was some class conflict within the guilds. And also we saw the rise of the nation state. So with the rise of the nation state, you also saw the decline of the monarchy. And monarchs, it turned out, it was a lot easier for a monarch to give letters patent, to patent things, to let you trademark. So these guilds are the roots of this stuff, patent and trademark and all that kind of stuff. So what is a patent? Does anybody want to guess? Sure, yeah, go ahead. Yeah, so that overlaps with trademark. So like if you're getting something patent, it's government permission to have exclusive use of that invention or to sell the right to use that invention to somebody else. So you're getting a monopoly, a government-granted monopoly power or control over that invention. And trademarks is the same thing, except for you're dealing with symbols. So you had these guilds coming up with symbols, and it was a way to brand their goods, and guilds had to protect their brands, and you had some guilds trying to do knockoff goods and the same sorts of things you see today with fake iPhones or fake purses that you might see on the streets of New York City being sold. Same problems existing then. Well, as the guilds began to decline, it also became more apparent that these were bad ideas. So in the 18th century, we sort of see the rise of classical economics. Professor Dove earlier talked about Adam Smith being the founder, or the father of modern economic thought. And the classical liberals, or the classical economists, recognized medieval guilds as monopolists and rent seekers. What do I mean by rent seeking? Does anybody know what rent seeking? Has anyone ever taken a class on public choice economics? It's a popular term in that field, but rent seeking is basically like the use of resources in ways that don't generate any wealth. Like you use resources without reciprocating the wealth or without generating any wealth. So you are securing economic rents that are higher than what you could normally make on the open market, in the free market. So essentially, you're not creating anything of value, you're just taking money. So in a situation where someone's just taking money in, but not actually producing anything of value for anybody else, that is typically a situation in which rent-seeking has occurred. Now, rent-seeking has a number of negative effects on several things: the quality and skills of the work, but also on innovation. It actually prohibits technological innovation and technological process. But another thing it does is it reallocates or redistributes resources to politically powerful people and away from everybody else who would benefit from that good. Really, the only people that are benefiting from a rent-seeking situation are the rent seekers. And Adam Smith sort of calls out guilds for all of this. Other things that guilds do, they distort market prices, they fix prices, and they deliberately exclude people from the practice. I mean, we've already talked about that, but that's their main purpose. So what does all this sound like? I mean, knowing that I'm about to talk about lawyers, what does this sound like? I mean, what does it take to become a lawyer? How do you become a lawyer? What do you have to do? What are the steps you have to take? Well, first you have to go to an undergraduate institution and get a bachelor's degree. Then you have to take an LSAT exam. Who's making money on the LSAT exam, by the way? Then you have to go to law school. Not 1 year, not 2 years, but 3 years. But you're not done yet. Then you have to take a bar exam. So you have all these prerequisites before you can practice. Well, guilds exist in the law in two forms that sort of work in concert, in my opinion, and that's through the American Bar Association, which has the accrediting powers over law schools, and through state bar associations. So what is the ABA? By the way, what do you call a smiling, courteous person at an ABA convention? The caterer. Okay, I said I was going to be done with jokes, but so the ABA is a nonprofit corporation incorporated in Illinois that operates as a trade union primarily for the benefit not of lawyers necessarily, but of law professors, really. And it is unlike a bar association in this respect. So what is a state bar association? Like, what is it? All these things that we talk about, companies and cities and counties, they're all entities. They're all creatures of statute or creatures of something, but what are they? So what is a bar association? What the heck is it? Is it government? Is it not government? Well, what most bar associations are legislatively created entities that give lawyers a monopoly over legal services, and they put state supreme courts in charge of them. So they're superintended by state supreme courts, but they are creatures of legislation, and because of that, they are sort of quasi-public, quasi-private entities. Now, the ABA itself has a pretty ugly history. So late 19th century, early 20th century, race relations were not good in the United States. And there were a lot of lawyers who thought that they could exclude certain minorities, certain immigrants, and other people, so entrepreneurial upstarts, from entering into the legal profession. They thought, oh, we cannot let just anybody come in and be a lawyer. We have to do something. We have to keep these people out. In part, the ABA was formed for that reason, and it has an ugly history. For most of the 20th century, it excluded African Americans from membership. For 66 years, it officially excluded them. In 1912, it came to light that 3 men had been admitted into the APA who were African American, and the ABA found out about it, and they ousted them. And not only did they oust them, but they issued a resolution saying this: "It has never been contemplated that members of the colored race should become members of this association." Now, recent decades have seen the ABA try to walk back a lot of its ugly history. It's tried to make up for its racist past by instituting committees and programs aimed at racial diversity and championing what are widely considered to be sort of left-wing social causes. But you can't turn something that is designed to exclude people into something else. By its nature, the ABA's function is to prevent people from coming in, and its ministrations continue to have a disproportionate impact on minority communities. There's a law review article called "No African American Lawyers Allowed: The Inefficient Racism of the ABA." It's in the Journal of Legal Education. It's published in 2003. It's a little bit dated in some respects now, but I would recommend that law review article to you on this topic. But it's interesting that in light of some of the regulations that the ABA seeks to implement and some of the measures that it takes to control, say, admission to the bar and law school education, that it would continue to do things that disproportionately impact minority students. Now, let's say that you didn't have to have ABA accredited schools. So there already exist night schools in a lot of places, and these are really inexpensive options for people. You know, they can go and pay very little for a legal education, and they can do it at night, which is convenient, but they opt not to. They opt to go to ABA accredited schools, which are more expensive and which sometimes force students to take out loans and these kinds of things. Why do they do it? Well, because state bar associations require that you graduate from an ABA accredited school if you want to sit for the bar exam in that state. So this is one way in which the bar associations and the ABA can work in concert. Now, there are a number of things the ABA does that force legal education to drive up costs. Number one is it determines the number of credit hours you need to graduate. So you can't do that 2-year program. You can't do a 1-year program. You got to go that 3-year program. It prohibits professors from maintaining profitable relationships with law firms and things like that, which could get them additional experience. So one unintended effect is that lawyers sometimes lose touch with the legal profession, forget how to practice law. It has these standards about requirements for equipment and technology that are pretty outmoded. Often you'll see law schools that just have a bunch of computers and things that no one uses, but they have to keep them there just to make the ABA happy. And just one kind of funny thing is that standard 306 in the ABA regulations defines technology as internet, video cassettes, DVDs, CD-ROMs. These are examples of technology according to the ABA. So all that stuff we talked about earlier with guilds prohibiting innovation and inhibiting progress in technology is evident in those ABA regulations. Another thing ABA does is they require you to report stuff, whether your jobs of people coming out of school are JD required or non-JD required. So Tim Cook could come to your law school right now, get a law degree, and then go back and be CEO of Apple, and you would report that as a non-JD required job, and the ABA would stick up their nose at you and say, that looks like, you know, that looks as though you brought someone into law school who didn't need a law degree to be there. Well, that doesn't seem to make sense in light of the changing nature of legal services and the need that the legal community has to adapt to technological change. That does not seem like a wise regulation. Now, all of these things force law schools to drive up prices, which essentially means that schools are reallocating resources to things like ABA compliance, which could be spent on student scholarships or making education better. There's a standard 316 right now that's being proposed by the ABA, which would require a 75% bar passage rate over a 5-year period for law schools. And I think this is a mistake for a number of reasons. You've got schools like in the state of California where the bar passage rates are already traditionally much lower because the bar exam is considered to be much tougher there. But also, the bar exam does not measure your ability to practice law. I mean, it's got a lot of archaic rules, a lot of what we call black letter law, but nothing about what it takes to be a lawyer, nothing about cultivating your legal skills. So really, your performance on that exam can have no measurable effect whatsoever, or no measurable predictive credibility when it comes to your talents as a lawyer, because it doesn't test that stuff. So let me talk about state bar associations for a minute. I already mentioned that these are creatures of legislation, that they create barriers to entry. But what do they do to protect lawyers from outside competition? Well, number one is the unauthorized practice of law. How many of you have heard of LegalZoom, a company called LegalZoom? A few people, yeah. So what does LegalZoom allow you to do? I mean, it gives you basic contracts. You can do a will. You can contract with people. Like, who's to say that like Jason Jewell over here, let's say I know that he writes great contracts, and he's not a lawyer, but he does a great job with contracts. Why couldn't I voluntarily, with the full knowledge that he's not a lawyer, say, hey, Jason, could you write this contract for me, and we do this, you know? Why couldn't we do that? I mean, Lysander Spooner, a 19th century jurist, suggested that all these restrictions on the unauthorized practice of law violated the freedom of contract, because people ought to be able to contract with whoever they wanted to contract with. If someone was really good at something, they should be able to perform that service without having to jump through all these other hurdles. So companies like LegalZoom get sued all the time for unauthorized practice of law, when really they're providing what most lawyers don't want to do anyway, could do in their sleep, you know, have their paralegals do. So that is one thing that bar associations do. Another thing they do is they restrict advertisements and commercials. Now, that may seem like a good idea to some of us who have seen a lot of lawyer commercials, you know, the one-call Mendenhall kind of things that you see up there. But think about what advertisements do. I mean, they disseminate knowledge. They give awareness to people about a service, and they allow for a healthy competition. Now, I mean, false advertisement is a different thing. If you're spreading falsehoods, that's one thing. But commercials in themselves are not bad. What about prohibitions, or at least limitations, on contingency fees? Contingency fees allow poor people to hire a lawyer and say, well, you're not going to get paid unless you win the case. And if you win the case, then you can take a portion of the earnings, of the winnings at the end. If you are regulating that and prohibiting people from doing that, then you're also prohibiting poor people from having access to justice, or for having legal representation, or having their day in court. These are all bad things. Bar associations require you to attend expensive CLEs, continuing legal education requirements. They impose expensive bar dues. They do all these things that drive up costs, which we already seen in law school. The costs have been driven up. Now you're entering a legal profession in which costs will be driven up. Well, all these costs have to be passed on to consumers in some way. And if the lawyers do not maintain total control, total monopoly power over legal services, then the costs would go down. So they desperately have to make sure they maintain that monopoly. Otherwise, if costs go down and people start competing with lawyers, and people start realizing, oh, you don't need a law degree to write a will, and that were allowed, then no one would hire a lawyer to do it, and the legal profession would be in a crisis. So Milton Friedman said this. He said, the overthrow of the medieval guild system was an indispensable first step in the rise of freedom in the Western world. It was a sign of the triumph of liberal ideas. In more recent decades, there has been a retrogression, an increasing tendency for particular occupations to be restricted to individuals licensed to practice them by the state. So this is a really big deal. Overthrowing The guild system in Western civilization was a big, big deal. And now we have professions that are trying to reinstitute the guild system, which we know is inefficient, which we know hinders progress in technology, which we know reallocates resources to the wealthy and powerful at the expense of everybody else, which we know drives up costs. Why do we let this happen? Well, what can you do about it? What can you do? If I were just to ask you, what can be done about this situation? What would you say? I mean, does anybody have a proposal for us? We could walk right out here. We're just like a mile from the legislature. We could go, I think I just telegraphed one of the answers. I mean, one thing you could do is bring up this stuff with your legislators. I mean, you'd have to have an informed view of these things, and you'd have to know what you're talking about, but it's worth talking to state legislatures. I mean, you don't have to go in there and say, let's abolish the Bar Association, and then people think, you're just too crazy, but you could say, hey, state legislature, you should look at this ABA thing over here. So the ABA almost lost its accreditation powers. In fact, there was a recent poll among deans of law schools, and it was sort of an anonymous thing, and a vast majority of law school deans said, yeah, you should strip the ABA of accreditation powers. Well, the Obama administration almost did, not for the same reason that the Trump administration might consider it. So the Obama administration thought that the ABA was too friendly with for-profit law schools that were taking advantage of poor people and bringing people into law school who couldn't graduate and didn't need to be there, and they were racking up student loans, and they were never going to have a chance at practicing law. So that was the Obama administration's view. Well, the Trump administration may have a different view. Their view may be that the ABA stuff is driving up costs. I mean, this is what's so interesting about this issue, is that it can unite the left and right. There's a reason for the left to want to do this kind of stuff, and there's a reason for the right to want to do this stuff. And in this day, we're so politically polarized, it strikes me as interesting that there is an issue out there on the table that no one really talks about. Another thing we could do is law schools. It would have to be the biggest law schools, the Harvards and the Yales. They could band together and do what Berkeley and Northwestern journalism schools did. Has anyone heard what Northwestern and Berkeley did? Their journalism schools basically just said, you know what, this accreditation stuff is really expensive and it's really pointless, and the accrediting body, which is the Accrediting Council on Education and Journalism and Mass Communication, is outmoded. It doesn't understand what we do. It doesn't understand journalism. Let's just forget it. So they just said, look, we're not getting accredited anymore. So when you have schools like Northwestern and Berkeley that are now unaccredited, well, that actually is a sign not of the lack of credibility of those institutions, which clearly are credible institutions. I mean, everybody recognizes those as leading research institutions in the United States, but that reflects on the credibility of the accreditor. It suggests that, oh, if schools like that are just ignoring them, then they must really be backward. Well, schools like Harvard and Yale and all these places could start doing that. Now, the reason why I think that's less likely is because of the state bar associations, which still require you to graduate from an ABA accredited school in order to sit for the bar and all that kind of stuff. So that's unlikely to be the answer, although if it works in conjunction with some of these others, it could be a part of the answer. Another thing you could do is, because state Supreme Courts are the superintending bodies over the state bar associations, and nothing stops you from writing letters to Supreme Court justices or sending them literature on this topic. If you see research on it, nothing stops you from sending that to a judge. It's not litigation. It's not like you've got a case before them or something like that. You just FYI, here's the stuff about bar associations. Here are the effects that bar associations have that disproportionately impact people of low to moderate incomes, or people that are of ethnic minority groups. Now, state legislatures, remember, they're the ones who created bar associations. So if you get state legislators thinking about these kinds of things, because state legislators don't really know how to think about things until you tell them what they're supposed to think about. So if you start getting them thinking about these things, then you put bar associations in sort of a precarious situation, and they'd have to respond in some way. It would be interesting to see what they do. But all of this requires education. So the main thing that we would have to do is just educate people about the economic consequences of guilds. I mean, we are, in the legal profession, a holdover from the medieval period, and lawyers are getting pretty rich off it. I mean, it is, I won't call it a racket, but lawyers make a lot of money. And this idea that there are too many lawyers, to me, is wrong, because what's so bad about having a lot of lawyers? Then I can hire them for cheap. I could get somebody to do a will for $10 rather than $300. That's not a bad thing, in my opinion. So I don't buy into this thing that there are too many lawyers, but there are too many regulations that enable the lawyers that we have to make more money than they probably would make on the open market. So that's in my opinion, why lawyers cost so much, and I'm happy to take questions on this topic. Yes?
Okay, for somebody that wants to be an entertainment lawyer, how would that work for them?
Well, it's interesting that you bring up the entertainment lawyer because you're actually operating with probably multiple guilds. You've got a writers guild, and you've got organizations like DreamWorks and all these other things. And but from a legal perspective, I mean, if you're a member of the bar, you're a member of the bar. You're part of that guild automatically, but you get to run up against other guilds and benefit from probably whatever monopoly or cartel powers they would have. Yes, from a lawyer. Do I have the laser pointer on my board?
Not yet. So, how would this argument play in the realm of the medical guild?
That's interesting, because Milton Friedman in Capitalism and Freedom goes after the AMA, the American Medical Association. So in that argument, it's the same thing. He has the same argument against the AMA. And his point is he says, look, I'm going to take, because the justification behind all these occupational licensures is that it protects the consumer, right? It protects the consumer. Now, you might have a question like, well, if you look at the communities that it's keeping out, what are they purporting to protect the consumer from? They could raise some troubling answers. But Milton Friedman says, I'm going to take the most extreme example, and I'm going to look at medical licensure and say, you've got to you got to go through all these things to become a doctor. He said, the reason I'm going to do that is because that's the strongest example. If I can make the case that the AMA is unnecessary, then pretty much everything else that does occupational licensure is off the table. I mean, there are occupational licensure things for like massage or massage therapy and florists. There's some for florists. It's interesting because I don't know how many florists are really destroying the health and welfare of people in their states. This is about protecting the consumer, and like, if we're protected, I mean, maybe there's like Little Shop of Horrors somewhere, and you got this man-eating plant, but I'm just not seeing that. Now, if flowers and industries like that were so dangerous, you would think that all 50 states would be regulating them. But the fact that there are like just a handful of states that regulate a handful of professions suggests that conditions across industries across states wouldn't possibly be all that different. So my answer is basically just to defer to Milton Friedman and say, read his chapter on the AMA, because I can't regurgitate all the arguments he made there. But yeah, he applies it to doctors and says if doctors shouldn't have to be licensed, then surely all these other people shouldn't. Any other questions? Okay. Yeah.
You said a moment ago it might not be a good idea to go to your legislature and say, let's abolish the State Bar Association.
Yeah.
What would be maybe an intermediate step towards reducing the power of the ABA and the legal profession at the state level? Something that the state legislature could do.
Well, I think the ABA is already getting close to being knocked off. I can't imagine in 10 years that the ABA is going to be accrediting law schools anymore. I just can't. So I think the ABA is close to not its demise, but at least its demise as an accreditor authorized by the DOE, the Department of Education. So the Department of Education is who authorizes the ABA to be accrediting body. And because of the way the DOE rules are, the ABA actually has to have a separate body that is its accrediting body that does different things from what the ABA does as a trade union. But at any rate, I think that's about to go. I really, truly do. Now, state bar associations, that's a little more difficult. You know, I think drawing it to legislators' attention would at least get the discussion started so that more entrepreneurial minds than mine could come up with solutions, you know. But one thing would be to have statutes that allow companies like LegalZoom to do business, or that overrule certain regulations that might be under like the professional ethics section of the bar, like things like advertising and stuff like that. Or if you are in a state that has regulation on contingency fees, which there were, legislatures have overridden laws like that in a lot of states. So if there are individual regulations that the bar is imposing, you know, you could pick those off one at a time through the state legislature and essentially just gradually evacuate bar associations of their unauthorized powers. But so that maybe that's the answer. I don't know. Any more questions? Yes.
What if you come from a school that does not have like pre-law stuff like this, and you don't know what to study on to get past or get into law school? How would you work around that?
Well, the first thing I'd say is if you want to be a lawyer, you have to do everything it takes to be a lawyer. And I think there are two different things going on here. One is, you know, a more theoretical and economic argument about what the bar is doing. The other one is if you want to be a lawyer, you still have to do all the hoop, and you probably don't have a lot of credibility if you're a law student saying, I should not have to take the bar exam. You know what I mean? Because every law student thinks that. But you know, if you're a lawyer, if you're a law student, you want to be a lawyer, do everything you're supposed to do, get licensed by the bar, be the best attorney you can be, build up credibility before you ever try to, you know, make arguments. Because if you make arguments without credibility, then no one's going to listen. Or if they do, they're going to dismiss the arguments. And if you want the arguments to really be listened to and to have the full force and effect that they could have, I think you've got to jump through all the hoops. You've got to be the apprentice. You've got to have your masterpiece. You've got to be the journeyman. You've got to do all those things and get through. But then there are people like me that are a traitor to their class who are up there saying these things. And there aren't many people that actually say that. I mean, a lot of people think I would be crazy for saying some of this stuff. But that's because when you go through law school and you go through all these things, you know, you get trained to think that you think differently as a lawyer. You're special. You're, you know, a privileged person. You regulate every other profession. And, you know, there's a little element of arrogance that gets sort of drilled into you over time. You sort of get inculcated into these arrogant ways of thinking. And it's hard to just give that up because everybody likes to think I'm the best, you know? Like, everyone wants to be, yeah, that's right, we are the best. We do all these great things. You know, if you go to different kinds of legal conventions and stuff, you'll hear a lot about all the great things that lawyers do. And they do great things, but a lot of the great things that are done could be done by non-lawyers as well, or wouldn't have to be done if you didn't have all these other restrictions. For example, like, you know, some of the cheap legal services that are offered, well, if you would have all those services equally as cheap on a free market, and you wouldn't have to have, you know, a government subsidized entity to perform those or to provide those, because everything would be that cheap if they were on a free market. Any more questions? Okay, one more.
Would the DOE take over accreditation under your proposal?
No, so if the DOE stripped the ABA of its accrediting powers, then it would fall to the state bar associations. So it would be a state-by-state thing, and it would allow the states to work with each other, you know, in some sort of comedy type way, COMITY. You know, it's like sort of like the full faith and credit idea. If you recognize this, but it would give you some negotiation, and the state bars could determine who can go in and who can go out. In our state, we have Miles and Birmingham, which are unaccredited. If you graduate from those schools, you can sit for a bar exam in the state of Alabama, but you can't anywhere else. Well, let's say Georgia has some unaccredited schools, ABA unaccredited schools too. Well, they might strike a deal with Alabama and say, hey, you know what? Graduates of this school could come here, graduates of this school could come here. But another thing that would happen is that people would start going to those unaccredited schools a lot more because they're like, oh my gosh, Well, now that I have more options, I can go to law school for like $5,000 a year rather than 30. I'm going to go there. And that would force schools that have higher tuition to really have to come up with things to drive costs down. Like there would be a race to the bottom for tuition. You know, people would have to figure out creative solutions to fix the tuition problem in what are currently ABA accredited schools, and the current non-accredited schools would enjoy probably a sudden surplus. You know, you would see a lot of people going to those, because the only reason people don't is because they're not accredited. You know, you don't have that mobility, but they're cheaper. And if you can become a lawyer and that's what you're interested in being, then that's a great option for you. Well, I think we're past time. I am conveniently the person giving closing remarks too, unless Anna Jane, would you like to say something too? I can yield the floor to you in a minute, but.
Yeah, I'll come up after.
Okay, she'll come up after me, but I just want to say thank you for coming here. Thank you to Fee for co-hosting this event. It's been fun, it's been exciting. We had a lot of people here this morning, and that was fun to see. And I hope we can continue working with organizations like Fee. Fee is one of my favorites, so I'm particularly thrilled to have them here on campus. And I'm grateful to all of you for coming. So thank you very much, and I will yield the floor to Anna Jane to dismiss us.